I'm going to just be talking about a few recent new new pieces of legislation. The first is LD 137. The official title is, an act regarding absence from work for emergency response. You have, I'm told, at a click away or something, copies of these newly enacted laws. This one was really just a technical correction to an existing law, technical clarification, but it's an existing law that perhaps not all employers are familiar with, or lawyers for that matter. And so it might behoove us to sort of go over it a little bit. It applies, this particular leave law applies to all private and public employers, and it covers firefighters, both municipal and volunteer, and emergency medical service providers, which are defined in the statute. And they are pretty much what you would expect they are. They're people who routinely, as part of their job, provide emergency medical services either at the scene of the patient's illness or injury or during transportation to a hospital. The statute prohibits the employer from taking adverse employment action against the firefighter or emergency medical services person who is late or absent from work because they're responding to an emergency in their capacity as a firefighter or an emergency medical services person. The employer may charge lost time against regular pay or available leave time. I was struck when reading this statute that it's not particularly friendly to firefighters or emergency medical services providers, but it at least does prevent employers from taking adverse action against them. It requires the employee to make every effort to get back to work as soon as reasonably possible after being released from the emergency. But it has very limited remedies for the employee. The employee may sue the employer within 1 year after the employee believes his or her rights were violated. And the employee is entitled to back pay, reinstatement, or other relief that would put the employee in as good a position had the employer not violated the statute. But the statute doesn't provide for attorney's fees, so that makes it difficult really for an aggrieved employee to bring an action. And then there's a bunch of ways in which the statute doesn't apply at all. It doesn't apply to employees designated as essential in a writing signed by the employer and the employee, where essential means the absence of the employee would cause significant disruption to the employer's business. The statute doesn't apply to police, utility workers, or medical personnel in the course of their regular employment as such, which that makes sense. The statute doesn't apply if the employee and the employer already have some written understanding between them that governs, quote, procedures to be followed when the employee is called to respond to an emergency. And then last but not least, the statute doesn't apply at all unless the chief of the fire department, with respect to firefighters, or the emergency medical services provider, meaning whoever it is that the emergency medical services person works for. The statute doesn't apply at all unless either the chief or the provider has a written policy specifying the circumstances under which the responders are needed to respond to the emergency. And the policy has to say that the responders will be released as soon as practicable, and the employee has to give the employer a copy of this written policy within 30 days of notifying the employer of the employee's status as a firefighter or emergency medical services person. So there's some real hoops to jump through if you're that the firefighter or the emergency medical responder has to jump through in order to even be covered by the statute. but it does provide some protection. I would expect that it would be an unusual situation when employers would want to penalize firefighters who are out there really, risking their lives and things. Anyway, the next piece of legislation has already been alluded to earlier today, and that's LD 183, and that's with respect to making Juneteenth, which is June 19th, but it's called Juneteenth. I have to confess, it's my own insulated upbringing, I'm sure, but I'd never heard of Juneteenth until the last, several months or so, which is just a function of my own, where I grew up and so forth. But anyway, Juneteenth, June 19th, is established as a state holiday in which all non-essential state offices are closed. It's added to the days that are not, quote, business days, unquote, under the state's banking laws, though banks may in their discretion remain open on Juneteenth or on any of the other days that are not, quote, business days under the statute. And Juneteenth is added to the list of, quote, unconditional holidays on which all public schools must be closed. So it's my understanding that a private employer, isn't required to recognize Juneteenth or frankly, any of these other holidays. But I would be a little careful because, of course, there are racial implications to Juneteenth, because Juneteenth was first celebrated in Galveston, Texas, of all places, when on June 19th, 1865, Union soldiers came into Galveston, and the slaves were there declared free in Texas, in all of Texas, I gather, even though this happened in Galveston, under the terms of the 1863 Emancipation Proclamation. I am no historian and definitely not a Civil War historian, but it is interesting, of course, the Emancipation Proclamation was a famous thing, but it had no practical effect, at least apparently in Texas, until 1865. In any event, Juneteenth became a federal holiday this past June. The other statute that I will mention is LD 335, and that amends Title 22, Section 8110. Title 22, Section 8110 was already on the books, and it already required DHS to obtain criminal history record information for any staff member, including any job applicant who may be offered employment as a staff member of a children's residential care facility, and already required that such staff members or applicants be fingerprinted. This amendment simply broadens the statute to apply not just to children's residential care facilities, but to emergency children's shelters, shelters for homeless children, or group homes that provide care for children.